Afternoon or good evening, depending on where you are in the world, and welcome to Finnegan's webcast, Alice Motions at the Pleading Stage in Patent Infringement Litigations in the United States. It's just past 1 p.m. Eastern here, so we're going to go ahead and get started. I am Caitlin O'Connell, and I'll be your moderator today. It's my pleasure to welcome our presenters, Justin Hasford and Stefan Okiana. Justin Hasford is a partner in our DC office who has experience in all areas of intellectual property law. His practice focuses on complex patent litigation at the trial and appellate levels on behalf of pioneer pharmaceutical companies. He has particular experience with cases arising from abbreviated new drug applications under the Hatch-Waxman Act. Justin has also litigated antitrust cases in business method patents. Justin is recognized as a next-generation lawyer by the Legal 500 US for patent litigation, and he counsels clients on issues of infringement, validity, enforceability, antitrust, unfair competition, licensing, due diligence, and IP portfolio management. He has extensive experience advising clients regarding the interplay between patent and regulatory laws, including Orange Book listing of patents for drugs approved by the Food and Drug Administration. Stefan is an associate in our DC office. Stefan prosecutes and provides strategic counseling on U.S. and foreign patent portfolios in the chemical and pharmaceutical arts. His experience also includes assisting with abbreviated new drug application litigation under the Hatch-Waxman Act, inter parte review proceedings at the U.S. Patent and Trademark Office, and disputes in district courts across the country. Prior to joining Finnegan, Stefan worked as a postdoctoral research scholar at Memorial Sloan Kettering Cancer Center, and he has a wide range of technical experience, including in the areas of organic and medicinal chemistry, computational chemistry, drug delivery, preclinical drug development, and chemical biology. Stefan has authored or co-authored 18 journal papers and a book chapter, presented his research at 13 national and local conferences, and is a co-inventor on many patent applications related to his postdoctoral work. Before I turn things over to our presenters, I invite everyone to participate in today's webinar by submitting questions. This is intended to be an interactive webinar, and you can click on the Q&A button at the bottom of the webcast interface and type your question into the Q&A window and then click submit. The questions will be answered today during the question and answer session, which will take place at the conclusion of the presentation. At any time during the presentation, you can enlarge the slide window by clicking on the Enlarge Window button on the top right side of the slides, and the slides will advance automatically throughout the event. If you are experiencing any technical difficulties, please click on the Webcast Help Guide button in the lower center of the webcast interface. Now it's my pleasure to turn it over to our presenters to begin our presentation, Alice Motions at the Pleading Stage in Patent Infringement Litigations in the United States. Justin and Stefan, the floor is yours.
Thank you so much for the nice introduction, Caitlin, and thank you everyone for joining us today. Today's agenda will cover the statute, 35 U.S.C. Section 101, and the Mayo-Alice test. We'll go through the two steps, the Alice Step 1 and Alice Step 2, and we will go through some cases that illustrate what courts have found to be abstract ideas and cases that have found the claims not to be abstract ideas. Then we're going to have a case study that my colleague Justin Hasford is going to go over, which is a recent decision from the Federal Circuit finding the asserted claims patent ineligible under 101, and the takeaways for patentees and accused infringers after a review of all these cases. So to proceed, first I want to go over the statute because one obvious question would be, are these exceptions part of the statute? So if you read carefully the statute, it is obvious that the subject matter described in Section 101 is broad. And even the Supreme Court has observed that the subject matter provisions of the patent law have been cast in broad terms, the goal to fulfill the constitutional and statutory goal of promoting the progress of science and useful arts. That said, and despite this broad mandate, the U.S. Supreme Court's precedents provide these three judicial exceptions that are listed in this box here: abstract ideas, products of nature, and laws of nature or natural phenomena. So the takeaway here is that while these exceptions are not required by the statutory text, they are implicitly read in the statute by the U.S. Supreme Court and are consistent with the notion that, for example, if you can see here in red that says any new and useful, it says process, machine, manufacture, or composition. So they're consistent with the notion that For example, a patentable process must be new and useful. So what can patent practitioners do when they face a one-on-one challenge at the United States Patent Office? Well, patent practitioners like myself rely on the guidances provided by the USPTO. As many of you may know, these are updated guidances and revised guidances that allow patent practitioners to help applicants get their patent applications through the United States Patent Office and provide guidance on how to overcome one-on-one rejections. For example, the guidances in my practice are helpful when looking to determine how to amend the claim language to mirror the examples found eligible in the guidance. We often do that because the examiners are not as trained in the case law. So if you are able as an applicant to mirror the guidance, then the chances of getting the patent through the United States Patent Office, your chances increase. So as a practical matter, if you're looking to prosecute an application that may have claims that may be subject to one-on-one challenge, the guidance is your first line of defense to get it through the SPTO. With that in mind, we just want to caution that the Federal Circuit has recently cautioned patent owners that the guidance is not itself the law of patent eligibility, and it is not binding on the patent eligibility analysis. So in cases where the guidance contradicts the case law must control. So again, this is just something to keep in mind, that as a good practice is, in addition to the guidance, a patent practitioner should also stay up to date with the case law to make sure they don't contradict each other. What we have here is a comparison of the case method, what we call the Alice-Mayo method, and the USPTO guidance method. When you first look at this, these two columns, you may think that they are different. In fact, they're not. Step 1 of Alice in the case method says to compare the claim to previous claims found to be directed to abstract ideas. Well, if you look at the SPTO guidance method, step 1 is split in two, 2A and 2A prong 1 and 2A prong 2. And what does that mean? Like in the Alice step 1, you have to look if the claim is directed to a judicial exception, if it's recited there. And then similar to Alice and Mayo test, at the same step 1, there's a second question says, you have to look at whether it is integrated into a practical application or not. And if it is integrated, again, in step 1 of Mayo and Alice-Mayo test, or the USPTO step 2A prong 2, then you are done with step 1. You overcome step 1. Your claim is not directed to an abstract idea, so you don't need to go to step 2. Similarly, in step 2, you have to ask if the claim recites additional elements to make it significantly more than the exception, something the courts call the search or the look for an inventive concept. Similarly, the USPTO guidance also look at step 2B is, does the claim provide an inventive concept? So it's a similar analysis, but the way the USPTO breaks it down is just to facilitate and help the examiners and the applicants to go through this process. One thing I want to highlight is that the improvements analysis in step 2A, so just to give a little bit more context, this prong 2 that says integrate into a practical application refers to essentially if you're doing an improvement in technology. So how you improve the technology, and instead of using, for example, a computer as a tool. So this is what this refers to. So what does that mean? So the improvements analysis in step 2A determines whether the claim pertains to an improvement to the functioning, for example, of a computer or to another technology without reference to what is well understood routine or conventional activity. That is, the claimed invention may integrate the judicial exception into a practical application by demonstrating that it improves the relevant existing technology, although it may not be an improvement over well understood routine conventional activity. So again, this is just to highlight that if there is an improvement in technology, you may have your claim, you can survive step 1 of Alice, and it's similar to what the courts do. However, sometimes you will see cases where this improvement in technology may be observed at step 2. So there is a mix sometimes in the case law. With that being said, I'm going to move to the next slide. So here we have the classic, the May-Alice Corp test. As you see here is the same question: is the PTO, is the claim directed to a process, machine, manufacturer? If the answer is yes, then you're going to do step 1 of ALICE. You're going to have to ask, is the claim directed to a law of nature, an actual phenomenon, or an abstract idea? If the answer is no, you get this green mark, means you're good to go. So your claims are patent eligible. If, however, the answer to step 1 is yes, then you go through step 2. And then if the claim does recite some additional elements that amount to something more than the judicial exception, again, the search for an inventive concept, then your claim can pass the ALICE manual test. Okay, so here, first we're going to go over, as I mentioned, over step 1 of the ALICE test. So, as you probably noticed from the title of our presentation, we want to provide some strategies to look when looking at challenging abstract claims in step 1. But at the same time, we'll also try to provide some guidance on how to defend against those challenges. So we'll try to provide takeaways from both patent owners and accused infringers. So you can use this to your advantage depending on what side you're on. So the first step we think it's helpful to do is to determine the character of the claim. What do we mean by the character of the claims? Well, the claims may be directed to, for example, data processing or organizing. What do we mean by that? For example, if they recite some simple data manipulation processes, such as reorganizing data, comparing data, manipulating data, and outputting the results, then the character of claim would be data processing or organizing. We like to call that either a bucket or a grouping of those claims. And the reason you want to do this grouping is because once you group it, you know what cases, for example, from the Federal Circuit, you can try to find to build an analogy that is in the bucket you're looking at, this character of the claim. But how do you determine the character? Well, in addition to examining the claim as a whole, you have to look at the specification. The specification is an important part in your analysis because that will provide some guidance on for example, all the claims, is the disclosure using some sort of conventional steps, or what is really the focus of the claimed advancement? Does it distinguish from the prior art? Does it say how it does, let's say, for example, an improvement in technology? Is that explicitly provided in the specification, and what kind of supporting information, if any, is provided? So, as I mentioned, we believe it's helpful to try to organize this in certain buckets or group them in certain, I'm going to call them buckets for the sake of this conversation of today's presentation, because I think that's the simplest way to follow. So if you put them in a bucket, that would allow you to then find cases, for example, from the Federal Circuit that are similar to your fact pattern. So for example, if you are the accused infringer and you're looking, let's say for bucket 2, you have a claim asserted against you that recites a mathematical equation, and it really seems that the focus of the claim is on the mathematical equation, and that mathematical equation is not, for example, part of a larger process, that you know you're in bucket 2. So you would look at cases that are in this mathematical concept bucket. Similarly, if you have a claim if you see a claim that's directed to data processing, then you would see some words such as reorganizing, comparing, collecting, manipulating, etc. And you will know, okay, I'm in bucket 1. This is the line of cases I should consider, either as a patent owner or as an accused infringer. That will be your starting point to know what you can either use to defend against a challenge of if the claims are invalid under 101, or conversely to say that to support the challenge. So to go through this process, we thought it would be beneficial to go through some cases that illustrate how you put them in certain buckets. And we think this would be a helpful list for you to have if you look at this process. And depending on the side you're on, you can use this to get some guidance on how the courts look at certain claims. So for example, we have data processing organizing, what we call here bucket 1. Here we listed 2 cases that, for example, will provide you guidance if you're looking at claims that are directed to data collection, recognition, and storage. This is the well-known content extraction case, where if a claim is directed to data collection, recognition, and storage, then the claim is directed to an abstract idea. And you also have to look to make sure that the claim doesn't recites something more. For example, you have to check whether the claim recites, for example, like here, just computer components performing routine and ordinary functions. If that is the case, then that you know this line of cases may be something you wanna look at. Conversely, if you are the, for example, the patent owner, and you're facing an accused infringer is trying to say, for example, that is trying to fight off this challenge, then you'll have to find cases that support your position. So to do that, Core Wireless is a nice example, because what it really says is that even if the basic concept is to summarize information, and that concept may be abstract, right, or is abstract, if the claims are, however, directed to some particular manner of summarizing and presenting information, then that is sufficient to take you out, step one, out of this abstract idea concept. And here, for example, the idea was that you could use, so the language basically in the claims were directed to an improvement in the functioning of computers, particularly those with small screens. So I will go over this in the next slides, but what you will take from today's presentation, I hope, is that if there is an improvement in, for example, computers or some device, those claims are likely to be found patent eligible and to pass this inquiry to step one. If, however, the claims are directed to using a device as a tool and there isn't an improvement, then those claims are likely not to survive a challenge. So mathematical concept. For mathematical concept, we highlighted here two cases that we think provide the takeaway message. And that is in SAP, for example, the focus of the claim was not on any improved computer or network, but was on the improved mathematical analysis. And indeed, the specification made clear that off-the-shelf computer technology was usable to carry out that analysis. Therefore, the claims are found to fall into those cases that are familiar, probably to many of you, that focus that do not focus, as I mentioned, on an improvement on computers as tools, but on certain independently abstract ideas that use computers as tools. So what is the take-home message from SAP? Is that no matter how new and unobvious the involved mathematics may be, if the advance lies entirely in the realm of abstract ideas, the claims may be found to be directed to an abstract idea. Compare that to Thales VisionX, where the claims were found to be similar to the ones in the Supreme Court case in Diamond versus Deere. If you remember in Deere, the court held that a computer-implemented process for curing rubber was patent eligible, but not because it involved the computer. In that case, in Deere, the claim employed a well-known mathematical equation, but it used that equation in a process designed to solve a technological problem in conventional industry practice. So similarly in Thales VisionX, the claims were directed to a particular configuration of sensors and a particular method of using the raw data. So even if the mathematical equation was required to complete the claimed method, the system itself was not doomed to abstraction. So again, here the court in Thales VisionX compared this case and found it very similar to the Deere case. Okay, mental processes. Here I just want to briefly go over, because it's not the focus of today's presentation, but in synopsis, one thing to keep in mind is if the asserted claims are so broad as to read on an individual performing the claim steps mentally or with a pencil and paper, then the claims are more likely to be found to be directed to a mental process. So in this particular case, the patents tried to incorporate a software code, but that was not enough to save the claims, because that lacked any computer implementation at all. Compare that again with CardioNet, and one word of caution here, where the claims were found not to be abstract, but it was, and here where the challenger tried to assert, to overgeneralize, to say, well, yes, doctors can do this mentally or manually, but sometimes making that assertion may not make much sense if you look at this particularity of the claim. So what the courts have cautioned is that it's not enough to assert that, for example, it is a mental process, and to say that, for example, doctors can do this mentally or manually, when clearly the steps in this particular case was to determine heat-beat variability could not be done by doctors mentally or manually. So it is difficult to fathom how doctors of the court took that stronger approach to highlight that. And in particular, in CardioNet, the claims were directed to a more accurate cardiac monitoring device, and that improved cardiac monitoring device was not an abstract idea. So, and again, this idea of improving a technology instead of using that technology, for example, a device as a tool, was sufficient in CardioNet to make sure the claims are not directed to a patent ineligible subject matter. So I'm going to let my colleague Caitlin go over this question with you guys.
Thanks, Stefan. So as I promised at the beginning, this is going to be an interactive webinar. So throughout today's presentation, we'll have a couple of poll questions, and we'll invite you to answer the questions, and then we'll walk through what we believe the answer to be and why we believe that is the correct answer. So here's our first question, and the question is, do prior art / novelty / routine steps matter in ALICE Step 1? So if everyone could please take a moment to consider that question, and you should be able to click either A for yes or B for no. Once a quorum has provided their answer, we will discuss the answer to this question.
Okay, so the answer here, it appears that it's almost split. That said, the answer is no. So the question of 102 and 103 is not part of the ALICE Step 1 inquiry, and courts have highlighted that in a number of cases. Okay, so the next part I want to go over is something to caution is that there's some things you may want to avoid in a Section 101 challenge, and the reason you want to avoid this is there is a tendency to overgeneralize. For example, when you try to define the character of the claims that we discussed. So is it data processing? Is it a mental is it a mathematical equation, etc. So if you do that, the risk is that the courts will see that you're not looking at the claim limitations, and may find it for the other party saying that there are all these claim limitations that clearly provide a practical application and overcome the or pass Step 1 of ALICE. So one thing to keep in mind is don't overgeneralize. If there is an asserted technical or logical improvement, look at that and make sure you address it. And look at the specificity of implementation. Are the claims to a particular solution? If you're the accused infringer, then you're going to say they're not. If you're the patent owner, this is how you fight back: specificity of implementation or technological improvement to make sure your claims survive the challenge. So we're going to go over a few cases just where we'll provide some highlights that go through these three things to keep in mind. Okay, so first, just want to highlight that the courts, as I mentioned, have cautioned that you need to be careful when you try to oversimplify the claims. Because if you do that, it is more likely than not that claims will be specific requirements will be found in the claims, and the courts will find that claims do pass the Step 1 of ALICE. Because, for example, in micro, the claim were directed to a specific improvement in computer animation, the automatic use of rules of a particular type. Compare that to SRI International, where again, there was this assertion that the claims were directed to a mental process. The problem with that is, and as the SRI argued and the Federal Circuit agreed, was that the human mind is not equipped to detect suspicious activity by using network monitors and analyzing network packets as recited by the claims. So again, you need to be careful when you say something is a mental process. For example, in this case, when it was clear that the human mind is just not equipped with certain processes, right? So you cannot just say it's a mental process. Clearly it's not, or you can, but it will not go in your favor. Another case that is a nice illustration is this data engine tax case. And one thing as an accused infringer, when you try to basically say that we're trying to attack a claim on 101, where you're trying to try to, for example, invalidate it, you'll try to look for a real world analogy. And the idea is to say that this has been done for many, many decades or for a very long time. You have to be careful when you do that. So for example, in data engine, the challenger cited to tab notebooks binder dividers, file folders, and sticky Post-it notes that were well-known examples of organizing information using tabs. And the court agreed with them that the tabs existed outside the context of electronic spreadsheets prior to the claimed invention. But the court said, it is not enough, however, to merely trace the invention to some real-world analogy. The eligibility question is not whether anyone has ever used tabs to organize information. That question is reserved, as we've learned from our poll, for sections 102 and 103. The question of abstraction is whether the claim is directed to the abstract idea itself. So you have to look at the claim as a whole to determine whether the claim is directed to an abstract idea or something more. Here, the challenger failed to appreciate the functional improvement achieved by the specifically recited notebook tabs that were in the claimed methods. And in this particular case, the notebook tabs were specific structures within the three-dimensional spreadsheet environment that allowed a user to avoid the burdensome task of navigating through spreadsheets in separate windows using arbitrary commands. So again, it's good to do this real-world analogy, but you need to be careful. Okay, so here we have, essentially is what we've been reiterating, is that the claim must recite an improvement to computer technology and not simply recite computer as a tool. So if you were looking to meet step one, then you are on the left, in the left bucket, so the left column. If you're trying to challenge to say it fails step one, then you're looking on the right column. And the only case I want to pause for a little bit is this affinity case, because we already went through micro and ANFISH, where, for example, the claimed cellular telephone was used to receive wireless signals. The claimed graphical user interface was used to display a menu of options to the user, and the claimed broadcasting system was used as a source of streaming content. So the claims were directed not to an improvement in cellular telephones, but simply to the use of cellular telephones as tools in the aid of a process focused on an abstract idea, and that it was not found to be enough to be patent eligible. So again, keep this in mind. The claim must recite an improvement to computer technology if you're looking to pass step one. If it doesn't, so even if it fails step one, you can always go to step two, but for example, if you can show that it passes step one, then you don't have to go through the step two. Okay, so here, one more thing we mentioned in the earlier slides is that the claim must recite how a result is achieved, right? Not simply claim the result itself. And just, for example, in Infringement, where the claim did meet step one, the claims were recited specific steps, generating a security profile that identified suspicious code and linking it to a downloadable that accomplished the desired result. So again, if the claim is specific, then there is a way to pass step one. Okay, so we have another question.
Thanks, Stefan. Here we have our second polling question of today's webinar, and our question here is, does technological improvement need to be recited in the claims themselves? Again, we'll give everybody some time to answer either A for yes or B for no.
So it seems that we have another almost 50-50. Most of you think that they need technological improvement need to be recited in the claim, and a little over 49% think that the answer is no. Well, the answer is no. The technological improvement does not need to be recited in the claims, and the courts have emphasized that. Okay, so we also wanted to provide during this webinar some prosecution litigation tips that may be helpful in your practice or when you're looking to either litigate or prosecute patents that may be subject to a one-on-one challenge. I think at base, all starts with drafting the application. It's not, we don't have this on the slide, but it's how you draft it. If you define the technology improvement and you distinguish it from the prior art, then that's the first step you can do. Keeping in mind what courts, for example, look at what's patentable and what's not, and having certain support in the specification may help a lot down the line when you have to prosecute and or litigate that patent. So it's a good idea to define technology improvement in the specification that could be used later to the patent owner's advantage in a litigation or during prosecution. Another piece of advice is to model claims based on those that were held eligible by courts and not just the PTO. That is, as I mentioned, courts sometimes if the guidance in some way is not in line with the law from the Federal Circuit, then the courts may, it's not binding. The guidance is not binding on the courts, so they can essentially still invalidate a claim. Work with the examiners to define the character of the claim, and of course, stay up to date with USPTO guidance and patent eligibility and court decisions on 101. Okay, I'd like now to shift gears to talking about ALICE Step 2. Step 2 is a search for the inventive concept in the claims. Okay, so here you only get to Step 2, as I hope you recognize based on the prior slides, is that if it has been established that the claim is directed to an abstract idea. And but that said, sometimes courts hesitate and say, even if the claim is directed to an abstract idea, so they fail Step 1, then nonetheless they pass Step 2 because there is an inventive concept in the claims. So here the court looks both at the claim elements individually and the combination of elements to see there is something different over the prior art. Okay, so here we have, essentially this is a nice table that shows the focus of Step 2 is really to see if the patentee can point to something in the claim that is unconventional. So now the case law is clear that 101 is not obviousness. Some say it's almost like obviousness light. So the key takeaway for accused infringers is that you want to establish that there's nothing unconventional about the claims. The claims are directed to conventional uses of conventional technology. Computers are used as computers. Phones are used as phones. The key takeaway for patentees is to establish that you came up with a technological solution to a technological problem. So you want to do this by how? Explaining how the prior solved the problem, explain how you did it differently, and explain how that difference is manifested in the claims. Okay, so here we have essentially, again, it just shows you what can pass and what cannot. So if you have non-routine and conventional, then they can pass, and if it's a non-conventional combination, can also pass. So here we have some arguments for and against meeting Step 2. We don't have a lot of time left for this part of the presentation, so I'm going to go relatively quickly through here. Just keep in mind that to meet Step 2, you can look at this line of cases, the Amdocs, Deere, and Sales Direct. For example, in Sales Direct, adding the second step, it was not known in the art to freeze the cells was found to meet Step 2. And then if you are looking for something that fails Step 2, then you can look at the line of cases of Ericsson, Bancorp, and Mayo. This is just a nice summary, just that you have here improvement of computer technology. So again, in Amdocs, the court found it persuasive that the claim solved the technological problem, which was the massive record of flows previously using big databases. Whereas in Ericsson, the court found that the claim was directed to controlling access to resources, and while there was a lot of dense claim language that was not sufficient by itself to save the claim. In Ericsson, there was also what the patent owner argued that would save the claim was not recited in the claim, and during claim construction, that architecture that they were argued was providing the inventive concept, again, was not construed as Ericsson took that position in that case. So in this case, Ericsson, essentially the court invalidated the claim because they found it not to provide an inventive concept. Okay, if you're looking for unconventional combination of steps, Bascom is a nice case to look at. This is because even if everything was known, the combination of steps was not, and in that case, the court found that to be sufficient to overcome Step 2. Compare that with Bosman, where that was not the case because the claims were essentially directed to collecting and analyzing data information, and in particular, the specification explained the steps were well known. And again, saying that in the specification is not going to help your position if you're trying to show that there's something unconventional. Okay, so here is just a quick list of items that do not qualify as an inventive concept. So we've been going through all this to essentially try to introduce you to the ALICE motions. How can you bring this challenge? You can bring it on a motion to dismiss, which is the ALICE motion. And the review here is limited to pleadings. The pleadings here will be the specification, right, the patent. If there is an expert declaration and it's part of the complaint, that will be included. And the prosecution history is also part of the intrinsic record. Here we have two cases where the motion to dismiss arguments were granted. The Dropbox case, where essentially showing that if the pleading has no more than a series of legal conclusions, the court is not bound to accept those as true. And content extraction is listed here, not only that the motion was granted on the 12b6, but noting that claim construction is not a prerequisite before ruling on an Alice motion. Okay, quickly here, if the court considers supporting documents, then the court may convert it to a summary judgment motion. With that in mind, we have another poll question for you.
Thanks, Stefan. So here is our last poll question of today's webinar. And this question asks, where can a party raise an Alice motion / challenge? A, the U.S. District Court only. B, PTAB and U.S. International Trade Commission, or ITC. Or C, both A and B. Again, we'll give everybody a little bit of time to answer this question. We will discuss the answer once the majority of the attendees have answered the question.
Okay, so it seems that the majority of you correctly answered that the answer is both A and B. So that's true. You can bring it in district court, PTAB, and ITC. A PTAB, you can bring it in a PGR. That's within 9 months when patent issues, and there's certain requirements that you need to be met when you do it. With that being said, I want to move this case to Justin Hasler, who's going to go over the case study.
All right. Well, thank you very much, Stefan and Caitlin. And so, yeah, we're going to switch now to a study of a case that our firm handled for our client, Castle Retail, which is a small family-owned grocery store chain in Memphis, Tennessee, against Hawk Technology Systems, in which we prevailed on a Rule 12 Alice 101 motion before the district court, and then that win was affirmed on appeal to Federal Circuit. So if we go here to slide 39, a little bit of background about the case. The case involved the 091 patent. It was asserted by, again, Hawk Technology Systems, and it relates to viewing stored images from video cameras on a generic computer device. And really the part of the idea here is the concept of storing digital information. It's video surveillance is what this case involves. And our client, Castle Retail, was sued because of the video surveillance system that they use to protect their grocery stores. Hawks claim one of their 091 patent is representative here. And what it's directed to is this viewing method on a remote viewing device of video surveillance involving receiving these images on a personal computer, digitizing them if they're not already in digital form, using an analog to digital converter, displaying them on a personal computer display device, converting them to a video format using these various temporal and spatial parameters, and then contemporaneously storing them in a storage device. There's a little bit more, providing a communications link to allow this external viewing device to access the storage device, receiving the images from this remote viewing device, transmitting them over the remote viewing device, and displaying them on a remote computing device. So just general basic ideas or really steps that can just be performed, if at all, on this generic computing device. And so this is an example really of what Stefan referred to as data processing and organizing under the Fed Circuit case law. And so if you look at the Electric Power Group case from the Fed Circuit in 2016, there the claims were focused on combining abstract idea processes. The advance that they purported to make was gathering and analyzing data, displaying the results. It's data manipulation is what it is. And that's what Hawk's 091 patent response to. The Intellectual Ventures 1 case out of the Fed Circuit in 2017 found or affirmed an abstract that the idea was abstract, where it involved converting video source images into a video format that provides no inventive concept, merely describes the functions of an abstract idea without any kind of particularity. And then in the Witserv case out of the Fed Circuit in 2020, again, the Federal Circuit found the claims at issue the abstract, the use there of standard computers and standard computer networks to carry out various functions, even if it was faster, more efficiently, more reliably, that didn't make the claims any less directed to the abstract idea that is not patent eligible. So what was argued in the district court's case? Well, Hawk sued our client, Castle Retail. We answered their complaint and filed our Alice motion at the same time. And so in our Alice motion, we argued that the claims of the 091 failed both steps of Alice. Each and every step of these claims is simply well understood, routine, conventional activity that is not patent eligible and that is amenable to resolution on an early Rule 12 101 motion under the Supreme Court's Alice guidance. We argued that there's this straightforward recitation of conventional video surveillance systems, generic recitation of conventional steps. Federal Circuit has repeatedly held that these sorts of data manipulation ideas are patent eligible concepts. Collecting information, analyzing it, displaying certain results, storing them. There's no particular inventive technology here. The specification provides generic descriptions, and that phrase temporal and spatial parameters in the claims, it's not even in the specification. The words temporal, spatial parameters, nowhere in the specification. So going then to slide 45, we also argued that these conventional components really provide no inventive concept. Personal computer, the analog to digital converter, the storage device, the communications link, the remote viewing device, they're all just conventional generic computer functionalities that implement this underlying abstract idea. Conventional broadband channels and generic PC server are basically admissions within the specification that this is nothing more than an abstract idea. And adding conventional functions and features that are known in the art doesn't render the claims non-abstract. Whether you consider them separately or as an ordered combination doesn't alter the conclusion. At Alice Step 2, they're patent ineligible, and they're not saved from abstraction. So Hawk opposed our Rule 12 motion and argued that, well, there's a presumption of validity under the patent statute, and the patent examiner never raised this 101 rejection during prosecution. We'll get a couple slides to how we responded to that. They argued that the asserted claims do meet steps 1 and 2. They argued that it wasn't an abstract idea. It solves this technical problem. There's specific tools and limitations in the claims. They recite a discrete implementation of a video surveillance system, and they claim that their invention achieves various unique benefits, generally speaking, directed to bandwidth and storage. And they also argued that, look, there ought to be claim construction and fact discovery here, and that can change the 101 analysis. And they also pointed to USPTO's new examination guidelines to address the Alice issues. And so we replied and said, look, Your Honor, they're really just improperly trying to manufacture a factual dispute where one doesn't exist. There's nothing in the patent disclosing any technical details for this digital video product system. Talks about conventional computing components, generic analog to digital converter. There's no mention of any temporal and spatial parameters in the spec. That cannot save the claims from abstraction. It is a fundamental process that video cameras have done for decades. It is video surveillance. It's been around since World War II in Germany in the 1940s. And the Patent Office's subject matter eligibility guidelines are just not applicable here. And to the extent those guidelines do contradict the Federal Circuit case law, it's the case law, and of course the Supreme Court precedent in Alice that controls. And Hawk, while they argued that claim construction might be necessary, they certainly didn't explain how it would change or alter the 101 analysis, and in fact, it would not. And so what did the district court say? The district court agreed with us and granted our Rule 12 motion and validated all of the claims under Section 101. The court said that Step 1, at Alice Step 1 that is, a method for storing and displaying video is simply an abstract idea. The 091 patent recites a process that video cameras have done for decades, video monitoring. And the use of improved displays or improved cameras doesn't prevent it from being an abstract idea under Step 1 of Alice. And manipulation of temporal and spatial parameters without additional concrete guidance, again, those phrases nowhere used in the specification, nowhere explained, that would be a claim directed to an abstract idea under Step 1 of Alice, and therefore the court found that the Hawks 091 patent did not pass muster under Alice Step 1. So going on to Alice Step 2, specification admits generic computer elements, conventional methods for the improvement. This analog to digital computer, personal computer-based system, they're not technological improvements. They're simply generic computer elements, off-the-shelf type computer functionalities. Parameters, this frame rate, which Hawk focused in on, they do not appear really to be anything more, the court found, than data manipulation, in this case images. And the claims, read in light of specification, don't in fact show a technical improvement in video storage and display, because again, these claim elements can be implemented using generic computer systems. And so the court found that at Alice Step 2, there was no recitation in the patent claims of any inventive step that was transformative that would save it from abstraction. And the district court again found these claims to be patent ineligible based on failing both Steps 1 and 2 of Alice. And so Hawk appealed to the Federal Circuit, and the Federal Circuit again affirmed the district court ruling in our favor. The claims at Alice Step 1 are directed to these conventional data manipulation type activities, and they don't disclose performing any sort of special data conversion or otherwise describe how to get this goal of conserving bandwidth while preserving data, any way of achieving it. Converting information from one form to another, including changing the format or video data, that's an abstract idea under the long line of Federal Circuit case law that we talked about in those previous slides, Witserv Intellectual Ventures, for example. And then the claims themselves just fail to provide a specific solution to make this alleged improvement. Conserving bandwidth while preserving quality, that's an abstract idea. And so the Federal Circuit found that these functionalities, these data manipulations that are set forth in the claims of Hawks 091 patent fail Step 1 of the Alice analysis. So then going to Step 2 here in slide 51, Federal Circuit said that even if these claims achieved the solution, that there was this bandwidth functionality that was beneficial in terms of the transmission, they only use generic functional language, and they require nothing other than a conventional computer, networking components, operating on their ordinary functions, personal computer, storage device, external viewing device. That's precisely, they just don't even say what these parameters are, these temporal and spatial parameters. And this is precisely the kind of lacking information that will not save a patent claim from abstraction under Step 2 of Alice. And again, the existing broadband media, the conventional technologies, Hawk hasn't pointed anything inventive in these claims, either individually or as an ordered combination. And accordingly, the court affirmed the district court's ruling that the 091 patent is patent ineligible under Alice. Its claims are directed to an abstract idea and fail to transform that abstract idea into patent eligible subject matter. Fail Step 1, fail Step 2. So Hawk had another more procedural challenge at the Federal Circuit, which the Federal Circuit ultimately rejected. And it's that our Rule 12 motion was allegedly procedurally premature. They said that the district court considered this testimony and other evidence outside of the pleadings, and they should have been permitted to engage in claim construction, and the Federal Circuit rejected that. They said that the district court, to the extent the district court considered anything outside of the pleadings, the district court's decision did not hinge on that. And Hawk argued that under Sixth Circuit law, where this case is pending in or was filed in the U.S. District Court for Western District of Tennessee in Memphis, regional circuit law would apply to procedural issues. So Sixth Circuit, Hawk said under Sixth Circuit law, the court was required to convert our Rule 12 motion into a Rule 56 summary judgment motion. Court didn't do that. Federal Circuit said to the extent that there was that requirement, it was harmless error that the court did not do that because the court was able to evaluate these patent claims on a Rule 12 motion based on the patent itself, the patent claims, and the specification. And so we'll wrap up here with a few takeaways for both patent owners and for alleged infringers when dealing with subject matter that may be amenable to an Alice motion on an early Alice motion under Rule 12 for adjudication of patent eligibility under Section 101. So for patent owners, and this takeaway is true for putting yourself in a situation to defeat a 101 motion. It's also for just Rule 12 motions in general. Factual assertions should be made in the complaint. That's just Twombly and Iqbal out of the Supreme Court in 07 and 08. Arguing combination could be helpful. Certainly making the complaint thorough enough to support whatever response might be. Relying on the prosecution history and the specification to bolster the strength of your claims. And to the extent an Alice motion is filed and it incorporates or refers to outside matters, those can potentially be challenged as not being suitable for resolution. And then for accused infringers, a lot of this, I think, were some useful avenues that we took in our case for Castle Retail. You can capitalize on unsupported attorney argument, capitalize on insufficient complaints, but also to the extent there are declarations that aren't submitted with the complaint, those should not be considered at the Alice stage. And certainly focusing in on the abstract nature of the claims, like we did in the case against Hawk at Alice Step 1, and arguing, of course, no inventive concept, both individually as an ordered combination in the claims at Alice Step 2, and that there should be, in fact, no deference to the fact that an examiner may not have raised a 101 rejection, or there is updated PTO guidance. That really isn't going to sway or move the needle really at the district court level. So with that, we have concluded, and we will be glad to take some questions that we have received from the audience. And so I'll turn it back over to Caitlin for the question and answer session.
Thank you, Justin and Stefan, for that informative presentation. Before we begin the question and answer portion of the event, we just would like to remind everybody to please take a moment to complete our brief evaluation survey. We strive to provide programs of value and continually improve, so we would appreciate your input, which will help guide us in planning future programs. We've received a number of great questions, but only have a bit of time left in today's presentation, so I will pose a couple of those questions to Justin and Stefan. But if anybody has any questions that have not been passed along to us yet, or that we do not get a chance to answer, please feel free to reach out to us. Our contact information will be at the end of the presentation and is also available on the Finnegan website. So the first question, and I will pose this to Justin, are there any steps practitioners can take to avoid early dismissals in subsequent litigation?
Sure, and thanks, Caitlin. Yeah, I think we could probably go back even to slide 54 here and look at some of them that we went through. But I think it's it probably does start as Stefan would tell you with the prosecution, but certainly bolstering your argument by relying on prosecution history, the specification, making an upfront argument that your claims aren't abstract. Certainly, there's no burden of proof on a patent owner to avoid a 101 motion. The burden of proof, of course, is on the challenger to prove invalidity by clear and convincing evidence. But I think doing some of these things that we mentioned in slide 54 can be useful.
Thanks, Justin. And then I will pose a question to Stefan. And that is, do you have any tips for navigating AI/software related patents at the PTAB?
Sure. Thank you for the question. We have a backup slide on that. Let's see if I can bring it up. But essentially is what I suggested during the seminar is to basically look at the guidance from the USPTO. And there's guidance, updated guidance 2019, that has an example that's directed to AI technology. So my first advice is look at the guidance, see what the USPTO finds patent eligible in the AI realm, and try to mirror the claims to what the USPTO finds. And then as the case law continues to develop, keep an eye on it to make sure that there are not other considerations that may need to be taken when drafting claims.
Okay. Well, with that, I think we are about out of time, so I will go ahead and wrap it up and thank everybody for attending today's webinar, Alice Motions at the Pleading Stage in Patent Infringement Litigations in the United States. This presentation will be available on demand in the next week, and you should please look out for an email from us with the link to access that. And with that, this concludes today's Finnegan webcast. Thank you all for participating.